We have more for your ears only. I'm Eddie Robinson.
I'm David Alpern with this quote from the news. I thought maybe it's time to take it easy, but this may change my mind. That was short story writer Alice Munro on winning the 2013 Nobel Prize in Literature. The Nobel Peace Prize went to the Organization for the Prohibition of Chemical Weapons, now active in Syria, despite a drumbeat of popular support for Malala Yousafzai, the Pakistani girl shot by the Taliban for her advocacy of women's education. She did win the European Union's Sakharov Human Rights Prize. Now this.
I think this is a fundamental free speech issue about your right to spend your money on as many candidates as you choose.
Freedom of speech, in my view, does not mean the freedom to buy the United States government.
Alabama businessman Sean McCutcheon explained on CBS News his Supreme Court case seeking to sever yet another arm of campaign finance reform, the aggregate limit on contributions to multiple candidates or political entities, which Vermont's independent Senator Bernie Sanders outside the court last week condemned as another step to rule by the richest.
Indeed, many political analysts traced at least one root of the current federal shutdown to the High Court's previous Citizens United decision, which permitted massive donations by corporations and other outside groups that help sustain the congressional contingent of extreme GOP conservatives. To consider the McCutcheon case and others on the court's full docket, we're joined again by Amy Howe, editor of SCOTUSblog.com, which analyzes proceedings at the Supreme Court of the United States. SCOTUS, welcome back to our program.
Hey, thanks for inviting me.
Who was arguing against McCutcheon's claim of cash as speech, as was already just judged in the Citizens United case, and on what grounds?
The Solicitor General of the United States, Don Verrilli, who's the government's top lawyer at the Supreme Court, was arguing at the court on behalf of the Federal Election Commission and against McCutcheon. His argument was that we need the aggregate limits on the campaign contributions to prevent corruption. If there aren't the aggregate limits, he explained, an individual could contribute as much as $3.6 million to individuals and political parties and political committees, and that would create corruption in the sense that it would allow candidates and parties to move the money around, and it would also, even if you weren't giving more than what's known as the base limit, the limit that you can give to an individual or a party, even if you weren't giving more than the base limit to any particular candidate or party, you'd still have an outsized influence because you were giving so much money overall.
And what can we tell from the justices' questions and reactions to the opposing arguments? First, those of the court's key conservatives.
Yes. So several of the conservative justices were very skeptical of the argument that you need these limits to prevent corruption. They said, well, an individual can already give large sums of money to political committees that act independently of the campaigns. And we've said that that isn't corrupting. And so how can it be corrupting for someone to give equally large amounts of money to candidates or political parties?
You found suggestions that Chief Justice John Roberts might be the deciding vote and that it might kill some of the limits in question but leave others. Which and why?
Exactly. The Chief Justice John Roberts, seemed receptive to the idea that if all of the aggregates limits are lifted and someone can contribute $3.6 million, that might create the appearance of corruption. But what he was troubled about was the scenario in which someone under the current law can give the maximum amount to 9 candidates, but can't, because of the aggregate limits, give that same amount of money to a 10th candidate. And he said, where's the corruption there? Limiting how much you can give to these candidates could cause somebody who feels very strongly about 2 issues, and the examples he gave were the environment and gun control, to have to choose, who am I going to support? Which issue am I going to prioritize?
Let's look at some other cases in what you say is being called a season of sequels. One of them this week involving another look at affirmative action by universities to achieve diversity. What are the specifics this time, and what's the constitutional issue?
Sure. So last term, at the very end of June, the court issued its decision in one affirmative action case called Fisher versus University of Texas at Austin. And that was a challenge brought by a young woman who was white, who believed that she had been the victim of discrimination because the University of Texas considered race as part of its application process. And so she said because of that policy, there were less qualified candidates who were minorities who were admitted to the university, and she was not. This is what one author, Stephen Wormiel, who writes for our blog, has called the mirror image of the Fisher case. This is not about whether or not a university can decide to use affirmative action so that it has a diverse student body. This case is about whether or not the state of Michigan can pass a constitutional amendment, which voters did in 2006 by a margin of 58 to 42%, whether they can pass an amendment to the Constitution of the state that prohibits public universities from using affirmative action, from considering race in its admissions process.
Now, there are two abortion-related cases on the docket, with one involving free speech for abortion opponents under the First Amendment. Talk about that and the arguments on both sides.
Sure. The federal law already protects a woman's access to an abortion clinic, but some states have decided to go further and provide more protection for women who are visiting abortion clinics. And this is a Massachusetts law that tries to do that. It draws a line 35 feet around abortion clinics and says that protesters can't go in that buffer zone. Now, on the other side of the equation, clinic employees can go within that buffer zone as long as any speech that they do there is something sort of acting within the scope of their employment. And so the abortion protesters challenged this law, arguing that it's unconstitutional, that it violates their First Amendment speech rights because it treats them differently than it treats the clinic employees.
Another case involves abortion-inducing drugs that permit women to avoid the abortion clinics that are becoming increasingly rare in many places in any event. What's the issue there?
This is a challenge to an Oklahoma law that allows doctors to prescribe these abortion-inducing drugs. It's what's known as a medical abortion as opposed to a surgical abortion. But it says that they can only do so in a way that's been approved by the Food and Drug Administration. Doctors in Oklahoma, and as I understand it, all over the country, are prescribing them using what's known as an off-label formulation. They use a combination of drugs that is different from what the FDA has approved because they consider it to be safer and because it allows women to take the drugs and have the medical abortions further into their pregnancies. So there's a challenge brought to this Oklahoma law. The argument is that it essentially eliminates medical abortions in the state of Oklahoma because virtually all doctors use the off-label formulation. And so it's something that they say that looks relatively benign on its face, but will actually eliminate most, if not all, medical abortions in Oklahoma. And this could be a scenario in which 5 members of the court's conservative majority pull together to make it harder for women to obtain an abortion, even if it doesn't reverse Roe versus Wade.
Amy Howe is the editor of SCOTUSblog.com.
Quote from the news, "Not much substantiation or sense of scale or the risk." That was United Nations spokesman Farhan Haq dismissing complaints about its peacekeeping forces by Transparency International UK. Also last week, the UN faced a class action lawsuit charging gross negligence by its peacekeepers in Haiti that caused a cholera epidemic.
Next, the power of the consumer. Research pioneer J.D. Power for your ears only.